episode of Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
Hello and happy Wednesday, everyone. Welcome. I'm Miliana, also known as the COE here at STS. As many of you guys know, Joel is in the courtroom right now. He is in Orlando covering the Sarah Boone trial. He will be bringing us some updates via the chat. So we are going to get some inside information from him, but I am here and I am joined by a best guest that many of you already know and love, law professor Joe Patuto. Joe Patuto is a law professor at the University of Nebraska Merida College of Law. She has also been bringing us a wealth of knowledge over the last couple of weeks, and we have been honored to have her for various cases that we've been covering. And today we are very, very lucky to have her. So welcome, Joe Patuto.
Thank you very much. Glad to be here.
Thank you. And Joe, you are definitely a night owl. I felt bad texting you around midnight. And then you texted me back at 2 a.m. and I was like, thank goodness.
Yeah, those are that's my best hour, 2, 3.
Good,
Nobody's
good. Well, thank you so
It's dark.
Well, thank you so much for being here. So I do want to let everyone know that we're waiting for Joel to hop in the chat to give us some updates. But the hearing is supposed to start today at 9:30. With that said, Joel texted me a few minutes ago saying that the judge is there and they may be taking a few defendants before. So they do have some people lined up that they're going to take care of before they get to the Sarah Boone hearing this morning. But just to get you guys up to speed, in case you don't know, one of the latest requests on behalf of Sarah Boone that her attorney asked the judge for was for more snacks. Joe, first off, what's your reaction to all of these requests? I mean, I know we had you on previously when she had asked for makeup, there was a wardrobe request, and now she's asking for a list of specific snacks.
Yes, including 5 peppermints, which was the one that struck me the most. Why not 7? Why not a box full? Why not 20? Why not a handful? But I will say one thing. Coming from New Jersey, and Joel will understand this, you might as well ask and be refused than not ask and never know. So to that extent, I don't say that I would applaud her, but to that extent, I understand her. But their requests are, let me say, peculiar. If you're hungry, if you think you need more sugar, then you would say that. If you think you need more salt, because I think she asked for 2 bags of chips, as I recall, then you would say that. If you say, I need a meal when I get back, you'd say that. But a precise list of 5 of this and 2 of this and 2 of something else is just, it does capture, I think, her personality. She is in control. She knows what she wants. She's going to ask what she wants. She's not going to leave it to chance to the judge or anybody else. She is going to let you know. And it just, every time I think about her, I wonder how the lawyers are going to deal with her. And that request, even though it was made of the judge, just underscores the what I think will be an interesting relationship and an observable, interesting relationship between her and her lawyers during the trial.
Well, absolutely. It's one thing to ask for something somewhat reasonable, but I believe I took some notes here. I believe her list was 2 juice packs, 5 peppermints, 2 bags of chips, candy, Pop-Tarts. As you said, these are very specific items. And her attorney said that she wakes up at 2:30 in the morning. That's the time she's woken up. Then she is in a holding cell till 6:30 in the morning. Then she finally gets to court around 9, and then is brought back later at 9 as well. So they're saying it's a very long day. The attorney did say that she is not diagnosed with any blood sugar issues, but in these long days, she gets very tired, as I'm sure anyone does. However, the judge did respond to the attorney and said, hey, listen, every inmate gets meals. Every inmate gets 2 bagged meals provided with cookies. And that's the protocol for any inmate that is at court waiting for some kind of trial or some kind of hearing. And that's usually pretty standard. And it's usually okay for just about everyone. So it's interesting that she's asking for all of these specific details. I mean, Pop-Tarts, the kind of candy she wants. It is obviously very descriptive and particular. And to have to be the attorney that then has to request all of this, I can't even imagine what that's like.
Right. Well, and I think the request also demonstrates that she does not see herself like any other inmate in the jail. She sees herself as special, and the requests underscore that she sees herself as special. What's good for everybody else is not good enough for Sarah Boone.
And Donna G here is saying, and who could eat during their murder trial? And that's the thing. I mean, she's not on vacation. She's not coming to meet someone. She's not going for a lunch date. She is on trial for murder. And if this was her loved one who, she claims to have loved him and been so devastated, and yet again, her focus is her hair, her wardrobe, her snacks, her chips, her candy. It's very telling about who she is. Yeah.
Me. And
Absolutely.
the wardrobe and the hair is me. And I know I'm going to be the star of the show. I want to look good for my audience. I mean, that's how it comes across to me. It's not that I'm on trial for second-degree murder of someone that I lived with and supposedly loved. It's I am the star of this production, and I need to look good for my fans who are going to be watching me in this production. She's got a very, and I think Dr. G said it on STS last night, she's got a very self-absorbed picture of who she is and what the trial is about. And for her, it doesn't seem the trial is about the fact that she kills someone. The trial is about this is her chance to be on stage.
Absolutely. And I just want to let everyone know, if you are just joining us, the hearing has not started yet. We are going to be taking it live once it begins. However, the judge is meeting with other defendants first. He has some other matters in the court to handle. He's going to do that first. And then the hearing will begin. And we're not quite sure how long it's going to last. Joel said that the prosecutor said it will take as long as it will take. So we'll see what that means. Joel did send me a video of himself this morning as he was walking into court. So I'm going to pull this up and we'll watch it. Give me a minute here.
Good Wednesday morning, STS Nation. It is Sarah Boone Day yet again. I am walking over to the courthouse right now, which is right over there, that tall building right there. This is downtown Orlando. It's kind of desolate. We are expecting this morning, beginning at 9:30, a pretrial motions hearing. The state says that they just got 550 pages of medical documents on Monday night, late Monday night, and so we're going to hear what's going to happen with all that. And the defense, James Owen, said that he planned to file his own motion. We don't really know what that is about. So we are planning to take the stream. However, we don't know if it is going to be active and accessible during this pretrial motions hearing. So either way, I'll be live chatting, and Joe Patuto, the professor, Prof. Poe, will be in that chat kind of explaining everything as it unfolds, whether we have the stream or not. So I'll see you guys in less than a half hour. Love you, America. See you, STS Nation. Holy crap, I'm in bad shape. I gotta get in better shape. Winded, walking, winded.
Is he pushing?
All right, well, that
something?
was... No, he's not pushing anything.
Oh, it looked like he was pushing something.
No, I think he's holding his camera out like this.
Yeah, that's what it is. Okay.
Yeah, I did give him a little tripod, a little gimbal that's supposed to stabilize the video, but I don't know if he knows how to open it or use it. He's also wearing his backpack, so maybe that's why he's winded. Or maybe his cardio is not that good, but that's all right. We love you, Joel. You're doing great. So we are also waiting, just so everyone knows, we are going to be taking the stream live when it goes live. But as of now, the judge is meeting with other defendants. We are waiting for Joel to hop in the chat right now. And I'm actually texting him, so give me 1 minute to remind him. Joel has been live tweeting, which is wonderful, but I would really love him in this chat so that he can bring us updates. He is sitting in the courtroom right now. He shared a photo, which I'm trying to multitask here and pull it up. But he did share a photo of some people who are bringing Sarah Boone her wardrobe every day. She did request a different outfit for the 2-week trial and for jury selection. So I'm going to be pulling that up right now. But while I do that, Joe, for anyone that's joining us and isn't familiar with this case, if you wouldn't mind giving us a recap of who Sarah Boone is and what's going on and what we can expect today while I pull up that video.
Yeah, sure. Sarah Boone, 4 years plus, I think it was in February 2020, was engaged in what she said was, and remember, everything that I'm saying comes from her because the victim in this case is dead and he can't report anything. So everything that's being described about that evening and what occurred is really coming from her. And she said they were engaged in a game of hide and seek, that the victim, her live-in boyfriend, had gotten into a suitcase, and they thought it would be funny if she zipped the suitcase up, which she did. And then she, at one point, she said that he tried to put his fingers outside the zip part of the suitcase, and she hit them with a baseball bat. And so he's in the suitcase. He is having trouble breathing, and she is taunting him. She sounds as though she might be inebriated, but she's taunting him. He's telling her he can't breathe, and she's not doing anything to help him. At some point, she reports that she goes up to bed and falls asleep, thinking that he's going to be able to get out of the suitcase. She comes down the next morning, finds him not breathing, calls her ex-husband, not first aid, but the emergency phone number, calls her ex-husband to come, and ultimately calls the police. Now, she and he had been living together for quite a while. They had what I would describe as a toxic relationship where they seemed to be mutual abusers. He hitting her, she hitting him. He was a relatively slight man. I think the report from the coroner's office after his death was that he weighed 105 pounds. So in terms of stature, weight, and everything else, they probably were pretty much on a par. He was not a husky, tall individual, muscular individual. But they'd had a toxic relationship, hitting each other. They apparently also both drank a lot. She said he was an alcoholic. Her ex-husband said she was an alcoholic. And he finally decided to separate and then divorce from her because of her drinking. So that's the situation in terms of the relationship. What happened that evening, he's then, as I said, he's found dead. She gives a couple of interviews to the police, one brief one at the scene where she's trying to explain what happened. She also gives a longer interview at the police station saying about what I said just now. And then she went through, she was in jail for 4+ years. She went through 8 different lawyers, at least 4 of whom left the case or were fired by her because they could not get along with her. She very evidently felt that this was her trial, her case, and that the lawyers were there to assist her and to follow her lead, and that the fact that they were law trained and had some expertise did not mean that they knew more than she did about how that defense should be handled. The judge then said, "You have had 8 lawyers and I've warned you. Now you're on your own. You're going to have to be your own lawyer. I am not going to go through another one of these delays while you try to find or we try to assist you in finding a ninth lawyer. Sarah Boone, over at least the last year, had been writing lengthy letters to the judge, some 50 pages long, describing her dissatisfaction with one or another of the lawyers, calling them names, describing them as not responsive to what she wanted, describing them as not providing her the documents that she needed to review. Once the judge told her she was on her own, she then created an advertisement that was placed asking for, and somewhere I had some description of this, but she wanted a clever lawyer, one who wanted TV time, one who would come on and take charge of this defense. And a couple of weeks later, the lawyer who's now on the case, James Owens, responded to that advertisement. He said somewhere along after he had made his first introduction to her that he really thought that this case needed to be pled out, that they shouldn't be going to trial. And it was his impression that because she was on her own, she was unable to handle plea negotiations. So he thought when he first met her that what he was going to do was negotiate some sort of plea. But he did not know Sarah Boone because she was not, and I think is not, willing to admit any kind of responsibility in this case. And so ultimately, James Owens took over the case. It's pro bono. The state is not paying for it. The judge said, we're not paying for anybody else for you. And if you've got money, you can pay for him. 2 other lawyers came on board, another one from Florida, and I think the third from New Mexico. They also have a legal assistant who's helping out at this point. None of them are being paid. And the trial was set to go last week. The hurricane came through. It was postponed a week. They started jury selection, what is this, the third day, Monday? And they've been going through, I believe, 50 at a time, trying to get a big enough pool from which then the lawyers will be able to individually conduct a voir dire. In other words, interview the jurors to see if they have any kind of bias or there are any reasons why they can't serve on the jury. This morning, there's an interruption of the jury selection of the pool because there's some motions that have been filed, a couple by the state, I believe a couple by the defendant. And once this gets started this morning, what they're going to do is go through those motions. So that takes us, I guess, up to where we are now.
That was a phenomenal recap. Everyone is giving you a 10 out of 10. Thank you, Joe. We appreciate that. And I know that many of you guys watching here are very familiar with this, but not everyone knows all of the facts. And again, the interesting thing about this case is not just what's going on now, but the lead up and the drama and all of the twists and turns and the unusual fact that she does have so many attorneys in her history of this trial, and there have been so many last minute surprises along the way. So I am seeing Joel. I'm not sure if he's trying to log into the studio or if he's going to be joining us via chat. So if you can hear me, Joel, please clarify. If you can't log on video wise, then please just join us in the chat and give us your updates instead of being on Twitter, please. Thank you. And I do want to play this video for everyone, and it is a trigger warning. So many of you guys have already seen it, but I am going to play the Suitcase video. This is a video that Sarah Boone herself took on her cell phone. It is triggering. I know many of you have seen it, but I just want to warn you. And this is obviously the last video we have of Jorge or George Torres before he was killed. So this is the video here.
Sarah. For everything you've done to me. Sarah. For everything you've done to me. Sarah. You. Sarah. You. Sarah. Stupid. Sarah. That's my name. Don't wear it up. Sarah. I can't breathe, babe. Seriously. Yeah, that's when you do when you choke me. Sarah. 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 Sarah, I can't breathe, babe. That's on you. Sarah, I can't breathe. That's on you. Sarah. Real or handsome. I want to get video for it extra. Because I got this. Sarah. Real or handsome. Sarah. Sarah, I can't breathe, babe. Oh. That's what Sarah. I feel like when you drink on me. Sarah. You. Breathe, Sarah. Yeah. You should probably shut the up. Sarah. Shh.
And so many people are saying it, like Elenator, friend of the show, saying it's hard to listen and watch this video. So many of us have seen it so many times and we've listened to it, and it really never gets easier to listen to that and to really understand that that was the last time that he was alive. And listening to her reacting to him begging for help is very, very disturbing, Joe.
Yes. And, I suppose all of us, in one time or another, maybe we're in a pool or in the water and we're underwater and we don't think we can breathe. And you can remember that panic that you felt. And he's in this closed suitcase where the air is slowly being breathed by him, knowing that he is dying. Unless she opens that suitcase, he's going to die. And that's what those were his last moments. And it's hard to see it as anything other than torture. She said initially that what happened was an accident, that she thought he'd be able to get out of the suitcase. She fell asleep, never expecting that he wouldn't be able to get out. About maybe a month ago, now I'm not quite sure, maybe a month, 6 weeks ago, she changed through her lawyers her defense in the case to say that she was a battered spouse, and that's a kind of a branch of self-defense. Self-defense typically requires a reasonable fear of imminent harm that you're responding to at the same level of the harm that's being directed at you. And the state has objected to her being able to use a battered spouse defense. The state says in order to have a battered spouse defense, you have to say you intended the action that killed. And she's never said she intended it. And if she hasn't intended it, she doesn't fall within the battered spouse defense. I think one of the motions today is a revisit of that motion that they, I think, made earlier, saying she shouldn't be able to use battered spouse. She should only be able to use it if she actually takes the stand and then lays the foundation. In other words, says enough to show that there is, on one version of the facts, were the jury to believe it, a basis for believing that she was actually a battered spouse. So I believe that's one of the motions that may come up again today. And it's something that, if it's still in question, the defense really would like to know, because if they don't know whether they're going to be able to use that defense, then they can't talk about it in opening. And they will be limited in terms of the state's case and what exactly they might be able to do. So anyway, that's where she is. She's been off. Those of you who don't know anything about this case, she has been, I've described her as a frenetic jumping bean. She seems to have been in every place one can be, claiming what happened that night. And if she does take the stand, she's going to be an incredibly, I think, bad witness. I don't think she's going to be able to maintain any kind of composure for any length of time. And in any event, she has so many inconsistent statements that I believe the state is just going to feel like they've been given a whole, plate full of desserts, and they have to decide which one to go for first in the cross.
Well, and it's interesting in this case, everything is shocking, yet nothing is surprising. I feel like every day there's something new, and yet it's not surprising because this is pretty on brand for Sarah Boone and for this trial season of hers. Joe, we have a question here from Annie K, and I do want to welcome Joel to the chat. Joel is in the courtroom. He cannot hear us, but he can participate in the chat. So as soon as he says something, he says, here we go. Let me pull this up and then I'll get right back to Annie K. I'm sitting with the court TV photographer and he's not set up yet as the judge is still dealing with matters delayed by Hurricane Milton. So we are clearly expected, we're expecting this hearing today to be delayed. There are other defendants and other dealings that the judge has to handle first. Once the hearing goes live, then we will take it live. We're not sure how long it's going to be. And Joe, hopefully you have some time. I apologize. But as soon as we have any updates from Joel in the court and we have it here in the back of our studio, once that camera goes live, then we'll pop it up for you guys. So we are going to be taking it live. But in the meantime, Joe, I hope you're okay with it, but we are going to be asking you a ton of questions.
Yes.
All right, so let's get back to Annie K here. She says, Joe, do you think it is right that the interviews and videos are all admitted against defense appeal to keep them out?
The judge is looking at all of it and evaluating against the rules of evidence what can come in and what can come out. And the fact that it appears as though they're all being admitted against the defendant simply says that the evidence right now is admissible. And trials are not a game, and I don't suggest, Annie K, that's what you're saying, but they're not a game where if I get 3, you need to get 1 back. If I'm doing really well and I've got 4 aces, then I get 4 aces. And the fact that you're hitting the net each time, is you're just not playing as good a game as I am. And I don't want to denigrate or, lessen the impact or say anything about this case, since it is a second-degree murder trial and it's a horrendous death. But the evidence is not good for her. The tape of the event, certainly relevant. It would be like if you were in another trial and let's say it was a civil trial and there was a tape of the car accident. You would expect to be able to use that and put it before the jury to show exactly what occurred. The tape is really pretty good evidence of what occurred. It's better than what her rendition of it would be. The interviews, to the extent that the law enforcement officer can get on the stand and relay what she said, hearing it in her own words is much more impactful for the jury. And it also allows them to evaluate credibility, to evaluate her reactions. In some cases that might help a defendant. In this case, I don't think it will. So yes, I think it's right.
Sorry about that. And we do have a super chat here from Kathy Quinn Ashby saying, I have a charm bracelet that I've had for years, and I just ordered a charm inscribed with justice for George, or justice for Jorge. I didn't know him, but yet he has a place in my heart. I don't want to forget him. His life did matter, and really all lives matter. So that's obviously very important when we're discussing these cases. We are talking about victims. We are talking about someone who lost their life, not by choice. I mean, they were stuffed in a suitcase and they died there. So this is a very sensitive matter, as are most of the cases that we discuss. I do want to just pop this up here. Joel says they are now getting ready for the Sarah Boone motions hearing. So they're getting ready. Once anything actually goes live, we'll pop that up for you. We are going to be taking the hearing here live, and the way it's going to work is like we do with other hearings. We will just play it live for you guys. When there's a break, when there's a pause in the hearing, Joe will give us her reactions. She'll break down anything that we're confused about. And then she'll answer our questions, and hopefully they get started here shortly. We're waiting any minute. So in the meantime, I'll take another question or two. And again, We do have it popped up here in the studio. I know you guys can't see it, but once it goes live, we will take it live. Some people are asking, is it better to get updates from Joel on Twitter? Joel does tweet. However, he's in our chat right now and we're going to be watching it live. So we will have everything for you guys. So do not worry. You won't miss anything. I do want to pop this up really quickly before we get started. This, Joe, is a photo from this morning. Joel sent both of these. This is outside of the Orange County Courthouse. And then on the left there, those are two women working for the defense team. And they are bringing in Sarah's clothing.
I see that. It looks like she's going to be wearing a suit again.
Yeah, it looks like, I don't have my glasses on, either navy or black. I'm unsure, but yeah.
They're wearing navy, so it looks like it might be dark gray and black, because against the navy, it doesn't look like it's navy, but you know, you may be right, maybe it is. So she's getting an outfit a day.
She's getting an outfit a day. That's what she had requested. She wanted to see she wanted to have different outfits for every day of a 2-week trial. Whether or not they'll repeat outfits, I'm unsure, especially since they're wearing these, neutral colors. It's easier to mix and match. But again, the fact that she is requesting a different outfit for every day of trial and is actually being granted that, I find very interesting.
Mm-hmm. I do too. Okay.
I'm
also wondering who's paying for all this.
Well, absolutely. And I have no idea, like, who would be. Is this on the state? Is this the defense attorney who's chipping in? Is this family members? Like, how would they have the means to do this?
It could be the latter two, either family members or the lawyers, although if the lawyers are already doing it without compensation and without right now a likelihood of compensation, it's interesting that they would be willing to put out more money to her sister. The state, if she's indigent, is not going to be paying for an outfit a day for her. She's entitled to have something so that she's not in prison garb, but that something wouldn't be, 2 weeks would be, 10 outfits. I mean, that's not a huge amount of money, but it's somebody's tax money going for it. If the state were paying for it or the county were paying for it. So I don't know. It'll be interesting. It'll be interesting to see if she agrees with the clothing choices that her lawyers are making for her, or whether that will be something else that she will have some kind of objection to with her lawyers.
All right, it looks like we are getting started here.
It looks black, doesn't it? Or dark gray.
Yeah, I think black. You're right. Or dark gray.
Yeah. And this is new because yesterday the blouse was kind of a green color. So now she has a white one. We should keep track to see if it's mix and match, or there actually are 10 different outfits.
We don't have any audio yet, but I'm sure they'll turn it on shortly. Just want to remind everyone, if you haven't already, please subscribe, please hit the like button, and thank you for being here. I am not the host of Surviving the Survivor. I'm just filling in today. I'm the COE. I'm Joel's wife, and we have the amazing law professor, Joe Patuto, who is one of our best guests, and we adore her being here. So thank you, Joe.
You're very sweet. She's got quite a file in front of her that she's going to be looking at while this goes on. I think when the jury selection starts again, of course, we won't see it, but it's too bad because it would be interesting to see how much she relies on her notes and how much she's making the choice about which jurors. Because I do believe that she's going to feel that's part of her job for the trial, to pick her jurors.
And apologies, the camera just went out. Oh, there we go. All right. And Joel, who is the host of the show, is there in the courtroom, and he's giving us some updates via chat. So I'm going to be pulling these up for you guys. He says 5 people in the gallery and 3 are part of Sarah's legal team. Obviously, that could change as the trial progresses, but for now, it looks like it's not a very packed courtroom.
Are you able to chat back to him? Can he hear you when you talk, Ileana?
He cannot hear us. He can only, because his phone is silenced because he's in the courtroom.
Sure.
So he can only chat. So he can, I can write something in the chat and he can read that. So if you have any questions, Joe, please feel free.
Okay. Does he think either of the other two might be family members of hers? I mean, I don't have a lot of sympathy for defendants in cases, particularly when there's a lot of evidence against them. But you know, I do sort of have a little bit of sympathy for someone who's in there by herself and there's no one from family or friends that are in there in support. It's got to be a very lonely feeling, although I'm not sure she feels lonely. I think she's very happy with herself, by herself.
I mean, I'm by no means a body language expert, but I feel like if I was in that position, sitting in that chair in that moment, my demeanor would be very different. And I feel like she has been very confident and has not shown any kind of emotion since we've seen her.
No.
So people are saying she
somebody now. Well, if you were to look at this from afar and you did not know that there was a defendant at that table on trial for second-degree murder, might you not think she was part of the lawyer team?
Oh, absolutely. Absolutely. I mean, that's the thing. When you're watching this, especially right now with no audio, you would think she's an attorney. You would think she's there to help. You'd think she's a paralegal. She's part of the team. She's part of that scene, but you would not think that she is on trial for murder.
Exactly.
And someone says, they say she acts like she is one of the lawyers.
Well, I think she not only feels like she's one of the lawyers, I think she feels that she's the lead lawyer. You know, she makes the decisions. They do what needs to be done. She needs them because they know what the rules of evidence are. She needs them because they know how to make an objection, when to make an objection, but she doesn't need them to decide substantively what the case is that's going to be made. I truly believe she thinks that's hers.
And someone in the chat here, Sunny Side Up, is saying, darn you, James Owens. So for a while, Sarah was planning to represent herself, which would have been very interesting.
It would have been interesting for us watching. It would not have been interesting, except in a very odd definition of interesting, for the prosecutor, for the judge, for the court clerks, for anybody else who had a role in getting the trial moving and ended. But it would have been, you know, high theater for those of us who didn't have any responsibility to see this trial proceed to a conclusion.
And Sharon Shipley just gave us a super chat. Thank you for that very kind comment. You're too sweet. Thank you. And then we have another one here from Kathy saying, why does she think killing somebody elevates her to a new status? She sure wasn't rolling fat before she got arrested.
I don't think she thinks she's been elevated to a new status. I mean, I'm not a psychologist. We all know that. But let me say that I don't think she thinks she's being elevated to a new status. I think she thinks she was already there. And this is just another job now at this status level.
All right. And people are asking where Joel is in the courtroom. So Joel is there, and I believe they have a media section. We don't have any audio yet. Just want to make sure. Space Coast, that's okay, no audio yet. Okay, so once they turn it on, we will hear something. They're probably just getting things set up there. But yes, Joel is in the courtroom. I believe he told me yesterday that there is a media section so that they're all on the side. So I think that's why we can't see him. I don't know if that's going to change once the actual trial begins, but for now, I think they're all on the side of the courtroom. I'm sorry, Joel's texting me. And so for all of you who are just joining us, the hearing has not started yet. We will be hearing the audio once it begins. This is happening out of Orange County, Florida. This is the Sarah Boone trial hearing. There were new motions filed, which is pretty on brand for Sarah Boone. And today we're going to be hearing a lot about what they're requesting and whether or not that's going to be granted.
William J. for the state.
Here we go.
Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Dr. Warner and Harper are the psychologists, one for the state, one for Sarah Boone, that interviewed her with regard to battered spouse syndrome. And what the judge just did was put on the record everything. So now there's a transcript of who's there, what was told, what their positions are, so there can't be any question on appeal that something was missing.
And Joe, in a hearing like this, what would be like a typical timeline in terms of how long something like this could take?
Well, there's no, I don't know that I'd say there's anything typical. It depends on the number of claims that are made, the substance to the claim. I mean, the ones that seem to be frivolous, they're being made for the record, but there's really nothing much to support, can be handled pretty quickly. Ones that have more substance to it. I mean, that the one motion there, the defense filed an answer and then filed an amended answer. That's, that's pretty. It's annoying to a judge to have to do that because
Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as one for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as state 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as state C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, I cannot breathe, now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Okay, so part of this is, were it not for a self-defense or battered spouse defense, instances of bad acts in the past, reputation evidence that you're violent would be hearsay and would not be admissible. But once the defense is raised,
Judge, if I could
that-
have you repeat that question.
Sure. So
that's
my
what evidence can come
understanding-
in.
Let me ask you, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear and she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? what happened next. And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, can I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yeah.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt act, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. as to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
On the prior motion, I think the state is very content with the judge's ruling, and we can talk about it after the
Response?
hearing.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir.
This motion relates to
2.8 instruction prior today. Thank you, Counselor.
statements by the detectives or by Boone during the interview.
Include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay.
The portion they have no objection to
Any other
is
argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments, for them not to put that in there. I disagree.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this in this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened And I don't know that it's relevant to what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since we have some level of common ground here.
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well, the state's position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures, I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure
Judge.
there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every
In
time,
2018?
2008.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, in the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what I know. You may have seen it, but the court hasn't seen it based on what's been filed.
believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning. Seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23, since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23. So.
Can you all approach just for a second?
Wow. They certainly are packing a lot in, aren't they?
Yeah, they're covering a lot. Obviously, a lot of different motions that they went through, and now even the possible concern of one potential juror already having
Right.
COVID and others being exposed to it.
Let
A lot
me-
of people.
Go ahead, excuse me.
No, I was going to say a lot of people in the chat were saying this has been a pretty heated hearing. Lots of spicy attitude back and forth. What's been your take so far?
That's exactly what I was going to say. The state started out, I thought, snarky when it talked about defendants can always change their mind and Sarah Boone can do it again. And then there was a fair amount of back and forth with what did not appear to be an amicable relationship between the state and the defense. To some extent, the defense seems to be remarkably disorganized. The failure to what appears to be the failure to file some of those documents and the exhibits and evidence they're going to use with the court is really surprising. And it's not new. Earlier on, there was an earlier episode in which the defense had not filed with the court that which needed to be filed with the court. I understand the prosecutor's frustration with this because it's not their obligation to get the defense in order, but they can't respond adequately if the defense has not provided the information in a coherent, cogent form in the way that it needs to be done. So they're kind of at a, we don't want to be doing their work for them, but we can't make some of our arguments as well as we should, or even get a start at it because they're not providing the information. So that was my take on that they're not, so far they're not getting along, and I don't expect it to get better. Now on the defense side, as Owen said, they've only been on the case about 45 days. She had documents, that in boxes. Earlier on, she had said, I need to see everything. This is when she still had lawyers before it was pro se, and she wanted things delivered to her.
Recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Okay, so there's a 15-minute recess. You just heard it there. So now we can get into more of the details. We're obviously looking still right now at the feed of Sarah Boone there. She didn't really react to anything, which obviously they're told not to have any reactions. But are you surprised with her demeanor today and how she's acting or not reacting?
A little, but I'm not so sure. I don't know the extent to which her reactions are fed by having an audience watching her and how much of them come naturally to her. So the fact that there's nobody in that courtroom right now but the judges, but the lawyers, the judge, and a couple of bystanders, there's no jury or anyone else there. She may just not being fed the energy she needs to be more emotive. So I'm not neither surprised nor unsurprised. Would that be the way to put it? by her demeanor. The lack of, the other overall general impression I have had is that the defense is not really keying in specifically and factually to what the judge is requesting. We're getting very general statements. And if I were the judge, I'd be very frustrated. And a couple of times when he interrupted, he was still polite, but it seems to me that he was showing his frustration that he couldn't get a specific answer. And you can't rule when you're getting generalities as to what the argument is. So that's kind of my general sense of all of it. We had enough time, we could start one of these motions. I don't know which one we would go to.
Joe, what about what I found interesting was the motion that was granted. It was the defense's motion, and it was essentially saying that under the Bush case, because law enforcement's opinions were came on too strong, the motion was granted, and those sentences now need to be redacted. I just wanted to go over that because obviously the interrogation, the interviews were very interesting. I know many of us have seen those interrogations of Sarah Boone, but they're specifically addressing page 534, line 11, where the detectives tell Sarah Boone well, he is dead as a result of your actions. And Sarah Boone responds on line 14 saying, I understand that. Then the detectives come back saying, I have one last question. You realize you're the person that killed him, right? And Sarah responds saying, I thought about that. So that conversation goes on for a couple of pages. That will now have to be taken out. How damning is that? Or do you think it doesn't really matter because the video is still so strong?
The video is still there, and I'm trying to remember what else in those interviews she said. I mean, she said that she zipped him in. So the fact that a statement that says, I understand I'm responsible, I don't think that matters very much. If you're on the jury and the defendant says, yes, I zipped him in, the evidence is you never unzipped him, you went to sleep and he died. You don't have to have a statement from the defendant saying, I'm responsible. Who else could be responsible but the defendant? So I was surprised he took that out anyway, because it didn't seem to me to really go to the issue of the police officer providing an opinion. I think what the judge is doing is being overly careful to take out anything that the defense is pointing to that they might use as an appealable issue, if there's a conviction. And that just didn't, that particular part of the interview didn't seem to me to matter. The part that he granted immediately was there was also information in the interview about her neighbors were not nice to her and they wouldn't let her use the toilet and those sorts of things, which would go to how difficult she is as a person and how maybe unlikable she is as a person, not relevant to anything in particular. So it was pretty clear that that part of the interview was going to come out. What happened is at the end, when the officer makes some statement about intentional or not, you're responsible, it was something like that. You may have the exact line there. When she was relying on it was only an accident, I don't think the judge would have excluded that statement because it would have been simply descriptive of what was true. Intentional or not, an accident is unintentional. She died. But now that they're segueing to a defense of battered spouse, where you have to intend to do the killing, that statement about intentional or not, you're responsible, does move towards an opinion as to what the law requires. That one seemed to me to be reasonable to just to take out. And the state's going to be able to. I mean, there's a lot of evidence in here. The state has to prove, if it comes to battered spouse, that she intended. The fact that the officer said to her, intentional or not, you're responsible, I don't think is going to move the needle very much. So I don't know that. Sure.
Oh, sorry. I have that line here, the one that you're referring to. It says,
right.
Well, intentional or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. And then the defense attorney came and said, the probative value is outweighed by the prejudicial effect.
Right.
And that's one that.
Yeah. Those statements to me are, don't move the needle much at all. And when a judge excludes where a defendant is objecting and it doesn't seem as though the state really needs it to prove a case, you often see a judge just kind of leaning on the side of the defense to take out, any issues, that are really not going to matter that much to the trial or to an appeal, but they might matter to an appeal if you don't get rid of them at the start. So I was surprised at the one statement that came out, as I said, but not particularly surprised that he agreed with the defense that all three of them would come out. I mean, there's just a lot of other evidence. And that goes to whether the probative value is outweighed by prejudiciality, because the probative value of an individual statement, or let me put it differently, an individual statement is less probative if you have 50 other things that show the same guilt, right?
Yeah.
So if it was the only thing there, then, if the only thing you had to show her responsibility was that part of it, then you might have a different decision as to whether probative value is outweighed by prejudiciality. But in this case, there's so many other things that it seemed to me he erred on the side of caution.
And speaking of guilt, so Sarah Boone is obviously not saying that she's completely innocent in this. She's saying that she has the self-defense battered spouse syndrome. So with that, I think when things started to get heated today in the hearing, it was really over the first motion. And
Right.
for those that missed it, I took some notes here, so I'm literally going to read my notes. It says that they were talking about a prelim ruling that if this is what her testimony is, we should not be asking for history of violence or battered spouse evidence. Case law supports that clearly this evidence can only come from her. There was no one else there in the apartment that night. So her testimony needs to meet the requirements of an overt act. And then the defense, the state, and even the judge all sort of went back and forth talking about an overt act. The defense even gave their own definition of what an overt act was. So sort of break this all down for us and explain to us, one, what this means and why was everyone getting so heated over this?
Okay, let's back up. Evidence as to your reputation for violence or the fact that in the past you committed violent acts doesn't necessarily come into evidence at trial. It has to be triggered by some claim or some piece of a defense the defendant is going to make. The defense here, which would be battered spouse, then the evidence as to he has a reputation for violence, he acted violently in the past, now is relevant because part of that defense is I'm responding the way I did because he's violent. So that the evidence that they're arguing about is the reputation evidence and the specific acts that have occurred in the past. The other thing they're arguing about is whether she will be able to even raise the battered spouse defense. So those are the evidence that can't come in unless there's that defense, or probably can't come in unless there's that defense, and the defense itself. So self-defense, independent of battered spouse, requires that the individual reasonably responds to an immediate threat of harm. And if the result is you kill somebody, then you have to be reasonably responding to a violent threat of serious harm, and serious harm would be major injury or death. So that's what has to be proved. What the battered spouse defense says is because you've been battered in the past, your assessment of whether it's reasonable and imminent may differ, and we will permit it because of the history of the battery. So that's where we are. The overt act they're talking about is you can't, as the defendant, whether it's battered spouse or not, say, gee, he beat me nearly to death a year ago, and now today I take a gun and shoot him in the head, because it's not imminent. So they're arguing about what the overt act is that triggered her response, that she had to act she had to respond violently. And you heard the state say she was the aggressor. She initiated. She didn't respond to anything he did. He's in the suitcase. She's zipped him in. There's nothing he's doing that she's responding to. She gets annoyed. She hits him. She's the aggressor. She can't be the person acting in self-defense because she started it. And that's the argument they were making about where is it that he, in the present circumstance, did something that permitted her to respond in a way that ended in his death. And the defense did not want to answer that. For a while, you were getting these generalities. She'll testify. I mean, it frustrated me. I'm sure it frustrated the judge. We'll tell you at trial, it has to come from her, et cetera, et cetera, et cetera. Finally, the lawyer said the threat was his fingers outside the suitcase. And when she saw the fingers, she thought that he was going to be able to get out of that suitcase and kill her. That's why she hit him. So she's not the aggressor. She's not the initiator. She's responding to the fingers coming out of the suitcase. And we're going to say, given her battered spouse syndrome, she was acting reasonably to believe that that was an imminent threat of death. That's the way that argument was going.
And the
Now you can-
attorney actually used this line. He said, referring to his hand outside of the suitcase, and he said there was a picture provided on Mr. Torres's hand outside of the suitcase. And he says, it's like a gun. You don't have to wait for them to pull the trigger, referring to the threat of Mr. Torres being in the suitcase, but having his hand visible. So I found that, yeah, I found that to be,
right. But the question is the analogy. If I've got a gun in the hand, it's pretty clear I can pull the trigger and shoot you. If I'm in a suitcase and I've got fingers, you know, whether you can, even assuming that she can raise this defense, that seeing the fingers should make her reasonably believe he's going to be able to get out of that suitcase and go after her. You know, assuming this is the defense they're making, that's the claim they're going to have to make. And I'm not sure with a jury, I mean, some of the people in the chat may have a better sense of this, whether that analogy is going to be very persuasive. That's the one they use to a jury, that the fingers sticking through this little space in the suitcase were equivalent to having a gun and being ready to shoot it, even given her claim of I'm a battered spouse and that's why I then responded. So anyway, that was the sequencing of the argument. Now, what else happened was the defense. I guess they didn't hear the prosecutor say, we're not arguing that you can do it in voir dire, because the issue is whether the defense will be able to raise it and when the defense will be able to raise battered spouse. Assuming that they're going to be able to raise it, you can't back up to before the jury was impaneled and find out whether any of the jurors would have been able to be impartial had that been the defense. So the prosecutor agrees that the defense is entitled to pursue whether it will have a jury that will be receptive to hearing that defense. You have to do it in front. It may be that by the time you go through the trial, the judge will say you haven't made enough of a sufficient basis to be able to raise the defense. May happen, but you can't wait for that to happen, because if you've impaneled a jury without knowing that it won't be biased, it'll be too late when you raise the judge permits the defense. It's too late then to have the right jury, to have the jury that it will be objective and unbiased to hear it. So they agree that it can be done in voir dire. The next question then was, can the defense in opening raise battered spouse? The prosecutor argued they shouldn't be able to do it until they've made the case that on the facts there's an overt act that says she could have reasonably believed and put that question at issue for the jury. The judge ultimately told the defense, you can do it. But if the defense raises battered spouse in an opening statement, and then the judge ultimately rules you haven't provided a basis whatsoever, so the defense will not be available to you, now the state will be able to say, look, they raised this. Did you hear any evidence about this? They raised something and then they didn't do anything with it. Typically, the prosecutor can't do that because that implicates the defendant's privilege against self-incrimination. You can't go after them for something that they didn't prove. But in a case in which they raise something in opening and then don't follow through, prosecutor said, now I'm going to be able to, and then battered spouse isn't allowed. Now I'm going to be able to point out that they raised something that never went anywhere. And that's probably true, although my guess would be, it's only a guess, that depending on the way the evidence goes, that they won't do it anyway because it still raises a potential issue on appeal. And I don't know that they would want to do that unless they really think they need to, or, at least it's, they're pretty confident that they don't have an appeal of a successful, defense doesn't have a successful appealable issue there. So that's as far as they got. They can do it in voir dire. Defense can do it in opening, but the defense has to first show the overt act before the defense can be raised. Now, what that probably means, because they talked about the defense witness, the forensic psychologist, who offered the opinion or will offer the opinion that she was a battered spouse. Now, if I'm going to offer an opinion as an expert, I have to base it on something. So if I'm an expert and I'm going to offer an opinion that you're a battered spouse, I have to point to evidence that shows that that's an available defense. So that whole argument they were making is there's nothing in the expert witness's report that shows an overt act. There was nothing that said the fingers were sticking through the suitcase. Apparently, the overt act that the defense is now going to claim. The prosecutor said there's nothing in that expert testimony that says anything that shows that there is a basis for the opportunity to use the defense. And you heard the defense saying, go ahead.
I just want to cut in because what you're saying is relevant to this comment that's up here from Cayuse Mag saying she said she left him in there because his finger was out and she thought he could get out, but now that finger is also what triggered her. So it's interesting because again, it goes both ways. It was sign of life saying, hey, his hand is out, he can get himself out, but now it's also this triggering point where she's saying she feels she needs to defend herself because the hand was there.
All over the place. She's been all over because she also said at some point, I don't remember where it was, that when she went upstairs, she thought he would be able, well, she did say this, she thought he'd be able to get out of the suitcase. She also said she thought he might come and kill her, but she figured, this is my language now, so what? You know, if that's what happens, it happens. So she's just going to be a mess on the stand because she's made so many different statements that go in so many different directions that, you know, the person in the chat was correct. No matter what she says, you're going to find statements that she made that undercut, if not directly contradict what she said. There's no question about it that that's going to happen.
And
so anyway,
notes, Joel, really quickly, he just said, Sarah's trying to read James Owen's cell phone while he's looking down at it. And he also said, Sarah just whispered some stuff to her private investigator who is sitting in the gallery. The judge just walked in. Oh, I think we may get started.
Okay, well, we can finish this once the hearing is over now.
We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
So he came back just so they could approach, huh? Well, she seems very happy.
Yeah, that's a very jovial expression considering why she's here.
I know. So the other piece of this is that the defense said the only person who's going to be able to show that there was an overt act is Sarah Boone, which sounds pretty clearly that she's going to testify. Because, I mean, I suppose it could come in through the one of the statements where she said his fingers were out and I hit it, but it sounds like she's going to have to testify. If that's true, and she's going to have to testify to establish the overt act, then it looks like she's going to have to testify before the expert witness testifies, because you can't get the expert witness's expert opinion in about the battered wife syndrome, unless she's already shown that there's an overt act here and it's not showing up in what the expert's report says now. So that may change. The judge may come to a different conclusion depending on what happens in the state's case, but that's the way it sounds to me right now. So.
Rosemary Romero, friend of the show, is asking this question. Why doesn't the judge just deny the self-defense or battered spouse defense? The judge doesn't believe her accusations based on the case law. And he did refer, I was trying to take notes on all the case law just because I wanted to look it up later, but I think he referred like 6 or 7 different cases.
Yeah. Yeah, and the way I take notes, I insert everywhere, and then when I have to figure out where they are, it's like it's worse than a jigsaw puzzle with 1,000 pieces, and they're all hidden in the closet and other places. I've never been able to break myself of this messy habit. In part because it's up to the jury to decide whether to believe that defense or not. What the judge has to do is to decide whether, and they talked about this, the summary judgment standard. A summary judgment standard is taking what the individual says in the best light of the individual, not questioning, gee, well, this counters or anything, just taking it in the best light. Does it show the basic elements are met? And her claim that it was the fingers that triggered it and she thought he was going to get out of the suitcase and kill her may be enough. Remember, the judge says all you needed was a scintilla of evidence to show it. So the judge may very well not believe it, but it's not up to him to make the factual conclusion. It's up to him to decide, is there just enough evidence to raise this, however crazy I may think it is there enough? And then it's up to the jury to assess whether that defense is viable or not, given the factual circumstances of the case.
And Joe, I'm listening to you, but I'm so distracted watching Sarah Boone because, again, what you said earlier, if you didn't know who she was, you would think that she's the attorney getting ready.
Lawyer.
Yeah. I think she has, is that a pen in her hand? Like, it looks like she's taking notes. She's flipping through things. She has folders, files. She's smirking. I mean, you would never think that she's the one on trial.
You would not. You would not. If you came into that courtroom and you saw the three of them and you were asked which one is the defendant, I think I would have to just, can't toss a coin because that's only two. I would have to have three little straws and just pick one because I wouldn't be able to do it from looking.
And Joe, earlier when there was some tension in the courtroom, in the first part of the hearing, in our chat, a lot of people were asking, should there be an issue or should Sarah be displeased with her attorneys? Once a trial begins, what are the rules with getting rid of an attorney? I mean, can she change her mind and say, I don't want to do this anymore?
Two things. One, and again, I'm not a psychologist, but I don't think she is going to continue to be happy with her lawyers because they're not crisp and precise and staccato enough. They meander a little, and I don't think that's her picture of what a really good lawyer would be. I think her picture of a really good lawyer is, dot, 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 dot. If she's dissatisfied, she can discharge a lawyer at any time.
It's her 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
It's her choice. But then she's going to be pro se at the trial. Then it's going to be her representing her.
Yeah, I mean, I don't even know what she's going through, but she's flipped through so many pieces of paper and folders now. I mean, I've never seen anyone so busy in a courtroom, and that's not her role. No.
Well, maybe it would be better for the defense lawyers if that's what she does, because if she's going to sit there and talk to one of them the whole time, I cannot imagine how you can handle a trial. Imagine doing anything. It doesn't have to be a trial, and somebody's in your ear the whole time talking to you. You can't do anything. Now, you, Ileana, COE, you might be able to do it because you're dealing with Joel and you're trying to do 3 or 4 things at once. But, the distraction of trying to do it is unbelievable. And she's not going to be happy if you're not responding to her. I mean, it isn't enough that it's coming in and you say, I'm going to find a way to block it out and do my job. She's not going to be happy unless you put her first. So I said, I think the only way it's going to work is they're going to have to assign a lawyer just to sit next to her and listen to her, who will not be doing anything directly in the trial, because otherwise she's going to distract the living, out of them. So.
Yeah, no, absolutely. And, going back to the hearings, and you were discussing the Overt Act and what it would take for Sarah Boone to be able to use the defense that she wants. some people were asking about different witnesses. Would witnesses have to be brought in on Mr. Torres's side, like family and friends describing their history? I know that originally they didn't want any kind of history of violence to be brought in. So obviously, I assume if they're doing that on one side, that they would have to do that for both sides.
Yeah, well, what will be relevant then is, was she responding as a battered spouse, or was she the batterer and he the battered spouse? I mean, once this comes in, I mean, they have, as I remember it, she made a couple of claims at least of domestic violence by him on her and got at least one court order, but he made at least one of her on him. So, you know, if it comes in and she makes the claim that he's the aggressor, he's the initiator, and she's the one who's in fear, so much fear that she became a battered spouse, and her version of the world is not ours because she's not able to see it independently and objectively. She's seeing it through the prism of somebody who's beaten in the past. Then I think it's open, you know, an open game for the state to say that's not the way it was. She was the batterer and he was the victim, or at least it was an equal, you know, an equal situation, and neither of them can claim that can claim the defense. Yeah. So it'll be interesting. I mean, you don't typically have one where each side can claim, at least in a criminal trial, each side can claim that the other is the one. When somebody's claiming battered spouse, I mean, in self-defense all the time, you get an argument, I shot you, and I say it's because you were coming at me with a knife. And there may well be an issue at trial as to which one of us was the aggressor at the level of force that was used. And so that happens frequently, but in a battered spouse situation, I'm not aware of a lot of situations in which either of them or both of them seem able to make the argument. So, but the defense did not want to put on the record and alert the state that their identification of the overt act was the 2 fingers or the 3 fingers in that space in the suitcase where the zipper wasn't entirely closed. That's what they were dancing around, did not want to say. And ultimately the lawyer said, you're forcing us to, you know, disclose our defense. We don't think we should have to do it. But since you're telling me that you're not going to be able to make a ruling unless we do, then this is what we say the overt act was.
Well, and the defense was saying, hey, listen, we shouldn't have to put on our trial right now in this hearing. But again, there had to be some kind of foundation since they are trying to kind of ruling on these motions.
Exactly. You can't just make a motion and say, you know, I'm raising this, let's go forward. You have to have some basis in the evidence. It may not have to be a lot. Or the judge say scintilla, but you've got to have something to permit it to be used at trial. Yeah. And obviously cross points there. Excuse me.
Yeah, no, absolutely. No, and I was going to say, you know, obviously they signed on very late. The state has had a lot of time to go over the case. They know what they're doing. They know the information. The defense attorneys are having to play catch up very quickly. With that said, overall, what was your assessment of them today? Do you think they're faring well, all things considered? Do you think they could have come better prepared? Do you think, because I'm just a civilian, I have no legal background, but watching, I mean, there appeared to be some confusion, some hesitation. I would hope that they don't have that same kind of tone and presentation during the trial, because I feel like that could affect the jury.
Yeah, I think that's James Owen's style. I mean, the style of some and a lot of trial lawyers that have come there, you know, guns blaring and, you know, here I am, I'm confident. Others portray a more diffident role, you know, a little less in control. Sometimes that works with the jury. But I don't think it's going to work with Sarah Boone. I think, as I said before, I think she's going to think he just doesn't know his job. And they are fumbling at times. You know, the fact that they don't have everything submitted to the court, I mean, that's amazing. I mean, that would be an easy one to do. If you're giving it to the defense, then you have it. I mean, it should be automatic. You do this and this simultaneously. I mean, there's no reason to do one and not the other. It should be, you know, I don't know, it should be almost second nature to do it. You heard them, the Fifth Amendment amended motion for some of the exhibits, I think it was. I mean, that's frustrating to the other side and frustrating to the judge that you keep amending things. That's explainable because they started so late. Some failure to identify if it's a failure to identify the particular question that the judge is asking and the request for a more directed factual response seem to be a little fumbling. On the other hand, in that first motion, it may well have been they really did not want to have to disclose that their argument as to overt act is the finger sticking out of the suitcase. And so they tried every way to dance around it and not answer it. I think, I mean, that's one strategy. I guess I would say that was an answer you were going to have to give the judge because you had to show something. And so maybe better just to say that you didn't think you had to because it was part of your defense strategy, but then say it immediately. And one of the answers really surprised me. It was the first lawyer on that first motion who said he had not read the state's deposition of their expert witness. He did not know what she told the state. That strikes me as just astonishing because you're going into a trial. Your witness is going to be there and you don't know what your witness told your adversary. I mean, that surprised me.
And some people are asking whether or not there's family there. I'm actually texting Joel while also listening to you, Joe.
Yeah.
So I haven't heard from him whether or not there's any family there. I would assume that the family will probably wait until the meat of the trial begins and opening statements begin. But we'll ask Joel once he's back here in the chat or even during his lunch live. He'll be able to fill us in on some of the information and give us more of the behind the scenes details of what's actually going on in the courtroom and who's there. I did also want to remind everyone today that this is one of 4 live streams that STS has today. It's the only one I'm hosting. Joel will be around for the other ones. So just wanted to give you guys a heads up. And here we go. We are back. So Joel says no family.
603, State of Florida versus Sarah Boone. State, you can get appearances.
William J. for the state.
Defense. Thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's 5th amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's 5th amended exhibit list was e-filed on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there, and also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date. which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time-stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? That will received without objection as states 4.
So just to give the court an example. On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline as a conversation that begins on Christmas of 2019. And it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too. I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. Mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe we'll give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the 2nd District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd 400 from the 4th District Court of Appeal decided in 2018. Gale, Gayle versus State, 216 Southern 3rd 656, 4th District Court of Appeal case 12 from 2017. The basics of these three cases are just a very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, But now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity, that these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image _0954. I don't know what that is. Image _0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted.
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As the foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling, that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person is going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state doing its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
Looks like he's going through all the photos to see if he's got any that have the sun in them. They said they got them all out.
Joe, do we think this will go for a while?
I don't know how many objections they have. I don't have anything in front of me that tells me that. It shouldn't be too long if they don't have many, but I don't know.
Of the folders, I don't have any independent recollection if I tidied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
And he didn't give any indication when he started how many of these there might be, so.
I just want to let everyone know, off topic, but important. My kids get out of school in 30 minutes. So should this still be going on, Joe has graciously offered to hold down the fort and keep this going. So if this does continue for another 20, 30 minutes, then I will head out and Joe will be here. And you guys are obviously in very good hands with law professor Joe Patuto. And Joe, thank you so much. I cannot thank you enough.
Sure. We don't want your children to be abandoned.
No, trust me, they will never let me let that down.
I don't see why they're arguing about this. If they've got pictures of the children, the state said they wouldn't introduce any. The defendant said they thought there were some. All they have to do is get rid of them. I don't know why they need to take up court time. They could just agree that the state will go back through and assure there are none, since there's no argument that they shouldn't be introducing any. So this confuses me a little. But I think it's partly that they're just not they're not dealing with each other very well. They're not communicating. They're each in their own silo and don't seem to want to build a bridge between the silos. If you can build, I don't even know what a silo is, but you get my idea. 2 towers, 2 independent towers.
And then in theory, they are supposed to go back to jury selection in an hour, I think.
Yeah.
Unless they're going to push everything back.
Well, the jurors are sitting, if you've ever been called to jury duty, you know, you just sit in the room downstairs and chat and get a coffee and just wait until you get called. So if they have to wait a little longer, somebody will go down and just alert them that they're not going to start quite at the time they were supposed to start. And they're going to they would have taken a lunch break. So, yeah. But if this is what they're doing, it's just, in my opinion, silly. This is like if you're doing an editing and you know you have to edit a sentence and you sit around the table while you're editing it rather than just say, I'll redo it and bring it back so you can look at it.
Yeah.
That's exactly what this is. But that's what they're doing. And I don't see how they could be doing anything else.
I couldn't recognize it as a reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those two exhibits that they're
I
talking
take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point
that-
that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now. They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right, thank you very much. Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I'm going to answer your question, Ileana.
They're in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
All right, so that was perfect timing for me because I have to go get my kids. Joe, so talk to me. What is your impression overall of today and everything that was going on right now? I mean, that seems so tedious and so many people in the chat, and even you were saying, like, did this have to be done now like this?
Well, it had to be done prior to trial, but it didn't have to be done like this. A lot of what they're bringing into the hearing is objections. They could have talked to each other and eliminated from anything that they had to do at a formal hearing, because take the pictures. State said they would not introduce any pictures of her son. Defendant found what a couple they thought were pictures of the son. They could have talked about all that before they got to a hearing, and there were other places like that that could have shortened it, but they're clearly not talking to each other. Now, in part, it may be the defense it's only been on it for 45 days. They're doing a lot of other things and they may not have allocated time to do it. But if so, if that's the defense's decision, I think it's ill-advised because it's taking more time to bring it to the judge who doesn't have a picture of the exhibit, so he doesn't know what they're arguing about. And at times they're not arguing about it anyway. And it could have been handled much more crisply and not gone to a hearing. But, you know, this I think may give you some sense of the way the trial is going to go. That they're not talking to each other, so everything is going to be sidebar, everything is going to be in front of the judge. I don't think to some extent the defense lawyers are listening to what the prosecutor says or the judge says. The prosecutor said any question about foundation, you know, you can object at trial. We're not claiming that you have to tell us now whether you think there's a foundation. In other words, can you show that the picture was taken on a particular date? And can somebody confirm that that is an accurate representation of the situation about which the picture was taken? And yet the defense lawyer kept raising, I don't know whether I can't waive foundation now. The judge then told him, you know, foundation you can raise at trial with regard to any particular exhibit. All we're doing now is assuming foundation. Do you have any objection to any of these pictures? And yet he must have raised it. I didn't take account, but I think at least 4 or 5 times. So again, it's wasting time, and it's I think it's simply not listening to what the prosecutor is agreeing to or conceding at what the judge is saying. And sometimes that happens. I mean, you get into this zone and you know what you want to say and nothing else gets in there. It's bad lawyering, it's bad interviewing, it's bad conversation with your friends. It's bad across the way. But there was a fair amount of that going on too. And I think I was trying to be objective about it. It seemed to me it was all coming from the defense side. I didn't see any instance in which the prosecutor misheard what the judge said or misunderstood what the defendant's position was. Sometimes they said they didn't know what it was because there was nothing that explained it. But anything that was said on the record at the hearing, it didn't seem to me the prosecutor was having any trouble tracking, but it seemed to me the defense was. So.
And the second chair seemed to be doing most of the heavy lifting today. Is that typical? You know, why would one attorney versus the other one take on the hearing and take on different motions in the hearing?
Yeah, it may be that the lawyer who is going to be doing the cross-examination of the state's witnesses with regard to the exhibits, you know, when this picture was taken, and is going to be the lawyer who was doing the objecting. So since he's going to be handling those witnesses at trial, he handled it at the hearing because, you know, you divide up the work. That's my guess. It may also be that they just divided things up quickly as to who was going to concentrate on what. And his turned out to be the ones that were the subject of the hearing today. But typically, when there's a preliminary hearing and you see somebody get up and make the argument about admissibility or something else, you can predict that lawyer is going to be the one that will handle that part of the trial when those issues come up. Since you're not doubling up, I mean, you do it for the preliminary and then it carries through to the trial. It's efficient, but I don't know that the defense is, gosh, I shouldn't be so negative about them, and I apologize because they didn't have much time, but it was inefficient today. Shouldn't have taken as long as it did.
Felt very inefficient. And I wonder what will play out differently as, you know, as the trial approaches and we get into the actual, you know, evidence and all of that.
Yeah, you're right. And if it's really an inability to track and hear what the precise claim is or the precise reason for a particular position or a precise request from the judge about what he wants, and that's endemic, then we're going to see it run through the trial, and it won't stop because it's a failure to track what's being said clearly enough. And I don't know whether it is or it isn't, because I do think, as I said, the argument on the first motion where I thought they were just going around in circles, it seemed to me that at the end, one could conclude that they were trying not to tell the prosecutor that they were going to use the fingers, There's an analogy from many years ago that I was thinking of as we were listening to this and it's an odd one, but I think it works. In the Iran hostage crisis, when we had the Americans being held, were being held in the embassy, and there was a lot of noise about how many are there. And the US kept saying, we don't know. And people were saying, how in the world can't you know how many diplomats, how many workers, how many, Marines, or how could you not know? You're incompetent. As it turned out, they were answering that way because they had 3 or 4 or 5 hostages in the Canadian embassy. And they did not want to give a number because they did not want to alert the, Iran that they could find some other hostages somewhere else. So that is what I was thinking of when he was not saying, and then ultimately he gave the answer. There was a reason why he was sort of skirting in generalities, because he did not want to have to disclose the information. So maybe that was going on in other places. I didn't detect it going on in other places. The one other thing I wanted to mention was the motion on the medical information on Jorge.
The records.
And yeah, in part I don't understand it, because it seems to me the evidence of him having to have the reconstructive surgery, which is what she did to him, seems to me would be pretty important evidence with regard to whether she should have a battered spouse defense, or what was going on. But in part, it seemed to me what the state was saying, and probably rightly so, is there were 2 instances that the defense wanted to get in. And if you allow in however many, it was 557 pages of documents, you may distract the jury into thinking, oh my God, there must have been all this violence, inflicted on her. And so the effort was to get it pared down so that you could see, you didn't have a mound of things happening. There were 2 incidents. And so I think so. And then part of it, I think I agreed with the state that the evidence that the brother supposedly beat up Jorge because she said Jorge had been violent with her. Again, what difference does that make? It's corroborative in the sense that she told, assuming that you believe her, that she told the brother that Jorge had beat her. But the fact that there's now a big fight and he's injured and all that seems not to go anywhere in terms of the particular legal issue. So
I think this will be an interesting trial.
Boy, will
it. I feel like every step of the way, we're constantly being taken aback by different moments, whether it be the attorney, the evidence, the defendant herself. A lot going on. Joe, I don't mean to rush you, but
no, you need to go.
I do have to rush you only because I have to get my kids. Thank you so much.
Great moderator. So
thank you. Thank you. I'm a bit of a rookie since I don't do this all the time anymore, but I just wanted to thank you for being amazing. Sure. We all adore you, and we love to hear your perspective and your knowledge on everything. So thank you so much.
Thank you.
And thank you to STS Nation, to all of our mods, to Space Coast, to Joel in the courthouse, and then again to Meave Moen. We are ending this right now, and Joel is going live. Thank you so much, everyone. Take